A destruction induced by undue influence, duress, or fraud is likewise ineffective. 8.3.4 Physical Act. A. Burning. The slightest singeing is sufficient. The part burned need not be material. B. Tearing. Most courts require the tearing to touch some material part of the paper of the physical will. C. Obliteration. To revoke, an obliteration must affect some material part of the will. Actions such as erasing or drawing lines through material provisions will normally be sufficient. D. Cancellation. Cancellation means drawing lines through words of the will. Actions such as writing void across the face of the will or drawing XS across the pages will normally be sufficient. Writing void in the margin is not a cancellation. E. Defacing testator's signature. Defacing the signature revokes the entire will, unless there was no intent to revoke. 8.3.5 Proxy revocation. The testator may direct someone else to destroy or cancel the will, but it must be done at the testator's request and in the testator's presence. Example: testatrix calls her attorney on the phone and says, "Tear up my will, I don't want it anymore." Attorney brings in 2 of his legal assistants to watch him tear up the will. The revocation is ineffective, because it was not done in the presence of testatrix even though it was at her direction and was done in the presence of 2 witnesses. 8.3.6 Partial revocation by physical act. In California, a will can be revoked in part as well as in whole by physical act. Interlineation of a holograph constitutes both revocation of an altered provision and a valid new disposition. The prior signature is adopted when the interlineation is made. Example: testator's will includes a $5,000 gift to Alice. Testator uses a black marker and crosses out the gift. Assuming there is sufficient evidence to prove that testator marked out the bequest, the gift to Alice is revoked. 8.3.7 Increase by physical act not permitted unless residuary. By canceling words in the will, the testator cannot increase a gift to a beneficiary. Although a resulting increase in the residuary gift is allowed, the testator can only decrease a gift to a beneficiary by this method. Example: testator's will includes a $5,000 gift to Alice. Testator uses a black marker, crosses out $5,000, and writes $10,000. Alice cannot receive $10,000 as the new gift was not executed with the formalities of a valid will. However, the $5,000 gift might be saved via the doctrine of dependent relative revocation discussed later. Compare. Testator's will includes a $5,000 gift to Alice with the residuary passing to Juan. Testator uses a black marker and crosses out the gift. The residuary gift to Juan has increased by $5,000. 8.3.8 Duplicate originals. Wills should never be executed with duplicate originals. The revocation by physical act of one original acts to revoke all the duplicate originals. 8.3.9 Effect of revocation on other testamentary instruments. Physical destruction of a codicil does not revoke a will, even if the testator so intends. Physical destruction of a will revokes all codicils thereto written on separate pieces of paper, unless the testator does not so intend. When the will and codicil are written on the same piece of paper, defacing the will portion revokes the codicil. But defacing the codicil portion does not revoke the will, unless the testator so intends. 8.4 Revocation by subsequent will or codicil. 8.4.1 Express revocation. A will may be expressly revoked by a later will or codicil executed with the formalities required for a valid will. An attested will may be revoked by a holographic will and vice versa. Example: testatrix's will contains a provision stating, "I hereby revoke all prior wills and codicils." This revokes all prior testamentary instruments. Compare. Testatrix's will states, "This is my last will." This does not revoke all prior testamentary instruments. 8.4.2 Implied revocation. Revocation by inconsistency. A will may be revoked by implication from the terms of a subsequent instrument. If the new will completely disposes of the testator's property, the old will is completely revoked by inconsistency. If the new will partially disposes of the testator's property, the old will is revoked only as to the inconsistent parts. If there is only a partial inconsistency and both instruments are admitted to probate, the mention of a child in either will is sufficient to preclude the child from claiming as a pretermit heir. Example: on January 1, 2020, testator executes a will which in part states that, "I leave my coin collection to Fred." On February 1, 2021, testator executes a new will that does not contain revocation language but which states, "I leave my coin collection to Mary." Fred's gift is revoked by inconsistency. CMR chart method: express revocation and instrument inconsistent provisions burning any portion of will, or tearing, obliterating, or canceling a material portion of will, with intent to revoke subsequent marriage or domestic partnership, birth or adoption of children, dissolution or annulment of marriage or domestic partnership, full or partial, either partial, except where will left everything to former spouse or domestic partner, result will revoked to extent stated in subsequent instrument. If no express revocation, prior will revoked only to extent inconsistent with provisions in subsequent instrument. Extrinsic evidence admissible to show whether testator intended partial or full revocation if only part of the will was destroyed, gifts abetted, and therefore revoked, to extent necessary to make up spouses or domestic partners, i.e. state share, gifts abetted to extent necessary to make up share for pretermit, shield all provisions in favor of former spouse or domestic partner. Revoked written instrument, physical act, operation of law, revocation of wills. QLTS prep by BARBRI. Wills, California. 64. 8.5 Presumptions. 8.5.1 Presumption of non-revocation. There is a presumption of non-revocation if the will is found in a normal location, and there are no suspicious circumstances surrounding it. A normal location is in the possession of a person to whom the testator delivered the will, or among the testator's valuable papers in a place the testator usually kept valuable papers, for example, a safe deposit box or filing cabinet. 8.5.2 Will not found at death presumed revoked. If the testator was competent until death, the will was last known to be in the testator's possession, and neither the will nor a duplicate is found at the testator's death, or the will is found in a damaged condition, it is presumed that the testator destroyed or damaged the will with intent to revoke. 8.5.3 Lost or destroyed wills. A will proponent may prove that a will cannot be found due to fire, flood, earthquake, riot, theft, etc., and rebut the presumption of revocation. Where a will is lost or destroyed without being revoked, the will is admissible to probate on adequate proof of its contents in the absence of any statute to the contrary. Some states have statutes limiting or prohibiting the probate of lost or destroyed wills, the effect of which may be to deny probate to unrevoked wills. 8.6 Revival of revoked wills. The fact pattern involving the revival of revoked wills looks like this. Testator executes valid will 1. Testator executes valid will 2 which expressly revokes will 1. Testator then validly revokes will 2. Is will 1 revived? Example. In 2018, Trish executed a will that devised her entire estate to her nephew Nathan. In 2020, she executed a new will that, after revoking the 2018 will, left her entire estate to John. Trish does not destroy the 2018 will. Trish changed her mind again and revoked the 2020 will by physical act but did not execute a new will. Does Trish die int state, or does the 2018 will revive? California follows the intent approach. The court will look at extrinsic evidence to determine what the testator intended. 8.6.1 If second will revoked by physical act. If will 2 is revoked by physical act, extrinsic evidence can prove the testator's intent to revive will 1. 8.6.2 If second will revoked by later will. If will 2 was revoked by a later will 3, will 1 is not revived except to the extent it appears from the terms of will 3 that the testator intended will 1 to take effect. Extrinsic evidence cannot be used to prove the testator's intent to revive will 1. 8.6.3 Revival by re-execution or republication. Will may first also be revived by re-execution, acknowledging signature or will in presence of attesting witnesses, or republication. By codicil, provided will 1 was valid and has not been destroyed. 8.7 Conditional revocation. 8.7.1 Express conditional revocation. The testator may state in the revoking instrument that a revocation is effective upon the happening, or non-happening, of a named event. 8.7.2 Implied conditional revocation or dependent relative revocation. The fact pattern involving dependent relative revocation, DRR, looks like this. Testator executes valid will 1. Testator validly revokes will 1, for example, by ripping it up. Testator executes will 2, but will 2 is invalid, for example, because it was typed with only one witness. The doctrine of dependent relative revocation applies when a testator revokes their will under the mistaken belief that another disposition of their property would be effective, and but for this mistaken belief, the testator would not have revoked the will. If the other disposition fails, the revocation also fails and the will remains in force. DRR is applied only if it comes closer to what the testator tried, but failed, to do than would an INTE state distribution. To determine whether DRR applies, we ask the following questions. Was the revocation of will 1 impliedly conditioned on the validity of will 2? Would testator have preferred will 1 over INTE Stacy? The more similar the provisions of the two wills, the more likely the court will apply DRR. The more different the wills, the more likely the testator would have preferred INTE Stacy to will 1, so the court will not apply DRR. Example. Testator executed valid will 1. This will left all of testator's estate to friend. On December 1, 2020, testator tore up will 1 and executed will 2. This will made a $40,000 gift to nephew and left the rest of testator's $1 million estate to friend. Will 2 is invalid because of a glitch with the execution formalities. Testator dies in 2021 survived by his children. At first glance, it would seem that testator died INTE state and the children would receive his estate. However, there is a good chance the court would apply the doctrine of dependent relative revocation. This doctrine would imply a condition on testator's revocation by physical act of will 1, that is, testator revoked will 1 based on the assumption that will 2 was valid because the terms of the wills are identical except for the additional gift to nephew. He would not have wanted his estate to pass by INTE Stacy. Because will 2 is not valid, the condition was not satisfied and thus the revocation of will 1 is ineffective. Accordingly, testator's estate passes under the terms of will 1. Compare. Assume in the prior example that will 2 had read, I leave $40,000 to nephew and the remainder of my estate to my children. A court is likely to conclude that testator meant to revoke the gift to friend regardless of the effectiveness of will 2. The disposition plans of the two instruments are so far apart that it would not be appropriate to assume that testator would have preferred will 1 to INTE Stacy. CMR exam tip. When considering when to apply DRR, remember, 1. There must be an alternative disposition, 2. The alternative disposition must be ineffective, and 3. If the revocation is by subsequent instrument, extrinsic evidence is not admissible to show the mistake. Also, be on the alert for a question in which the subsequent instrument revoking the will and making the alternative disposition is defectively executed. In that case, The revocation is also ineffective and there is no need to apply DRR. 9 Will contests. 9.1 Procedural aspects. 9.1.1 Standing. Only interested parties, that is, those whose interests would be adversely affected by the admission of the will, have standing to contest a will. This includes heirs, because they would receive the estate by INTE Stacy if the will is invalid, and beneficiaries of prior wills, because if the will is invalid, property would pass under the testator's prior will. Creditors, executors, and testamentary trustees are not interested parties. 9.1.2 Burden of proof. The burden of proof is on the will contestant. 9.1.3 Timing and notice. A will contest must be filed within 120 days after the will is admitted to probate. Note that this is a very short period of time. Many states allow a contest to occur years later. All legatees under the will and all INTE state heirs are necessary parties and are entitled to notice. 9.1.4 Will may fail either partially or entirely. If only a portion of a will is found to have been procured by undue influence, fraud, duress, or mistake, only that part is void and the remainder is given effect. 9.2 Grounds for contest in general. A will contest challenges the validity of a document offered for probate. Grounds for challenge are 1. Defective execution. 2. Revocation. 3. Lack of testamentary capacity. 4. Lack of testamentary intent. 5. Undue influence or duress. 6. Fraud. And 7. Mistake. 9.3 Failure to meet elements of valid will. A will may be contested for the failure to meet the elements of a valid will. This includes a lack of legal capacity, testamentary capacity, testamentary intent, or necessary formalities. 9.4 Insane delusion. Insane delusion is a distinct form of incapacity. A person with testamentary capacity may have an insane delusion that can invalidate an entire will or a portion thereof. An insane delusion is a belief in facts that do not exist and that no rational person would believe existed. A will can be set aside for an insane delusion only if there is a connection, nexus, between the insane delusion and the property disposition. Example: I could believe you are a space alien who has come to Earth to destroy us, but it doesn't affect my will because I leave everything to Margaret, my wife. But if I believe Margaret is an alien and thus do not leave her my property, then the insane delusion voids the will. 9.5 Undue influence. A person can hound and badger someone to make a will. Only if the influence is undue is there a problem. The execution or revocation of a will or a part of a will is ineffective to the extent the execution or revocation was procured by undue influence. Undue influence is 1. Excessive persuasion that causes another to act or refrain from acting. 2. By overcoming that person's free will. And 3. Results in a property disposition the person would not otherwise have made. Influence is not undue unless the free will of the testator is destroyed and the resulting testamentary disposition reflects the desires, not of the testator, but of the party exerting undue influence. 9.5.1 Elements. To establish undue influence, the contestants must establish that influence was exerted on the testator. The effect of the influence was to overpower the mind and free will of the testator, so that the will reflects the desires of the person exerting the influence instead of the testator, and the product of the influence was a will that the testator would not have executed but for the influence. Causation. CMR exam tip. For exam purposes, keep in mind that mere pleading, begging, nagging, cajoling, or even threatening do not constitute undue influence. The free will of the testator must be destroyed. 9.5.2 Evidence to prove undue influence. A direct evidence. Direct evidence is seldom available because the testator is dead and the person who exerted the influence will lie. Usually, there are no other witnesses to the alleged undue influence. B. Circumstantial evidence. Undue influence is usually proven by circumstantial evidence, which requires showing a number of factors that, when combined, justify the inference of undue influence. Usually one of the factors alone is insufficient to establish undue influence, but different combinations of factors may suffice. Note that none of them, or even all of them, are conclusive that undue influence existed. Although other factors may be taken into account, for example, dispositions at variance with the decedent's stated intentions, unnatural dispositions, in determining whether undue influence caused the result, the court must consider the victim's vulnerability, the ability of the testator to resist, the influencer's apparent authority, the relationship the influencer had to the victim, the actions and tactics of the influencer, for example, controlling the victim's access to necessities or people, use of affection or intimidation, initiating changes to the victim's property or personal rights, and the equity of the result, for example, were close family members cut out without a good reason. Note that the mere opportunity to exert undue influence does not show that undue influence was actually exerted. 9.5.3 Common Law Rebuttable Presumption of Undue Influence. A presumption of undue influence, which shifts the burden of proof, arises when a confidential relationship existed between the testator and the beneficiary. The beneficiary actively participated in some way in procuring or drafting the will, and the beneficiary unduly benefits from the instrument, that is, provisions of the will appear to be unnatural.